Yeah. United States versus Rangolan? Yeah. Because the summary contempt sanction is not subject to the usual requirements of a jury trial. Oh, or notice and opportunity to be heard. Summary contempt is a rule of necessity reserved for exception circumstances and a narrow category of contempt. Oh. Now, just so you know, Jack, yes, I can actually subpoena the court clerk. Yes. And I can ask her, did you change the court date? Oh. Um, you and the prosecuting attorney, yes, will not have those same jury trial. Now, what's really interesting, right? Or notice an opportunity to be heard. I oftentimes have mentioned that I hadn't gotten notice or opportunity to be heard. Ooh. Now, when you think about it, okay, petitioner, yes. And then, is this a forgery or not? Oh, protected person. Oh. And then we have the fraudulent Exhibit A. Now, looking at Exhibit A, Jack, yes, you're going to get sued. Yes, as is Jefferson Associated Counsel. Oops. The county of Jefferson County. Sorry, Sheriff Stanko. You're getting sued. Now, you will not get notice or an opportunity to be heard. Summary contempt is a rule of necessity. We cannot have prosecuting attorneys changing court dates because they get upset. We can't have public defenders that lie to their clients. Right. And if, oh, yeah, we can't have that. Now, I did not get reasonable notice and an opportunity to be heard. Brent Pooch says the same thing on this one. Responded did not receive actual notice of the hearing. When do you not get notice and opportunity to be heard? When you find yourself summary contempt sanctions of the court. Now, just so the Jefferson County does understand, yes. Mhm. I'm going to want the sheriff's department to enforce the laws of the United States. Port Townsend Police Department, oh, the misconduct of the attorneys representing the state of Washington, as well as the attorneys representing myself, it's criminal contempt to change court dates because you're just unhappy, Poach, to call me 20 minutes before the arrest that was going to take place the next day. I'm sure Judge Landis would have issued another failure to appear. And I would have had to explain, well, Judge, my notice says that, oh, criminal contempt of court. So you won't get notice and opportunity to be heard, just so you understand. Yes. And I was supposed to receive notice and an opportunity to be heard. Oh. Now, I mentioned each of these court cases. Yes. This dissolution of marriage, Judge Aurora? Yes. This default dissolution of marriage? Right. I did not receive notice and opportunity to be heard here. Yes. At the settlement conference setting hearing? Yes. I did not receive notice and opportunity to be heard at the motion hearing. Brent Basden? Yes. I did not receive notice and opportunity to be heard at the December 31st of 2012 hearing. No. I did not receive notice and opportunity to be heard on January 3rd of 2013. Now, this was a clerical error and it was always supposed to be the 3rd of January. Because I don't see, yes, any hearing date as January 3rd of 2013. Yes. Now, usually this court case, yes, that evidence is fraud. Uh, you can't change the dates. I talked to you about that. Right. Right. And then when you had this motion hearing, you should have set another date. Yes. 914. Oh, 914 notice of hearing for temporary order 10/5 of 2012. And then the motion hearing on 10/5 of 2012. Yes. Trial clerk setting. On 1/3 of 2013. Yes. And then setting for uh, February 11th of 2013. Yeah. Now the trial clerk set the hearing for February 11th of 2013. Yes. And then the trial clerk did it again, right? Because the mail was returned unclaimed. Ooch. Exactly. Where'd you send that mail? Ooch. It wasn't in the ground. Now, since you didn't have that hearing on December 31st of 2012, yes. And you didn't have a hearing on January 3rd of 2013, yes. And you didn't have a hearing on January 22nd of 2013, yes. This trial clerk that did all the trial clerk settings of the 1-day non-jury trial that did it twice, yes. Is this a clerk of the court or is it some other individual employed in the court? Now, we've had some difficulty with people deciding to have court dates. Yes. I don't think the deputy prosecuting attorney had the actual authority of my right to a jury trial. Yes. Notice an opportunity to be heard. Is this an exception circumstance? Ooch. And a narrow category of contempt? Ooch. Citing Harris versus. I think it is. Exactly. Now, I was looking at this Canadian documentation. Yes, yes, yes. A lawyer also has a duty to maintain an honest relationship with opposing counsel. Is it honest of the deputy prosecuting attorney to change court dates without allowing for the public defender to know about it? Oh, it's all hearsay. Is that right, Brett? Coach, you think I'm making this shit up? Coach, wait until I subpoena the court clerk. Oops. Wait until my public defender takes the stand under oath and I ask him, did you know the court date was changed after we had the court hearing? Oh, it was a holiday. I can oh. In that case, during the course of the litigation, a court official instructed a lawyer that the trial, which was scheduled to begin in 3 days, had been taken off the trial list. Now, this is Canadian law. Yes, it is. As if the court date that was scheduled for September 28th of 2018 had been changed. Now, the lawyer undertook to inform opposing counsel. Yes, opposing counsel. However, in the hopes of reaching a settlement with the defendant, known as myself, the lawyer did not tell opposing counsel immediately, but instead sent a revised offer to settle. Oh, opposing counsel, known as the public defender, subsequently discovered from a different source. Maybe a video that I make, maybe an email that I send, that the trial had been adjourned. Oh my gosh. The case had been dismissed and my public defender didn't know it. It was a mistrial and we didn't know that. And nobody emailed. The discipline panel, yes, held that the lawyer was under an obligation to the court, as in contempt of court misbehavior, to promptly pass on the information. It rejected the Canadian judicial system disciplinary, yes, that the argument that this was a situation analogous to that a lawyer possessed of information developed during the adversarial process for the use of his clients. Now, isn't it somewhat contemptuous? Yes, discriminatory. I would say to not have me and my public defender know the moment somebody I know. Now, the trial clerk that decided to set this court hearing, yes, I didn't get notice of that, and nobody told me they were. Now, you would think that as the named respondent, right, the individual known as the father of the five sons, that changing court dates, yes, and making adjustments to court dates, yes. This mail returned unclaimed, yes. I had a right to know. Now, when there were two trial clerks setting actions, yes, on January 1st, or January 3rd, yes, but ki- you're not in contempt of court, are you, court clerk? Oh, see, I put a little stamp right here. The judicial process, adversarial and conflictual in nature, should not increase the conflict, yes, between parents and cause additional harm to children. Yes. There is a significant body of evidence to suggest that the more protracted the conflict in the judicial process, the greater the harm to children. Now, this protracted conflict of judicial process that we've been having for the last 3 years, let me give you an example. You decided to issue a dissolution of marriage when I didn't know about due process. You decided to issue protection orders. I didn't know about due process. You decided to serve me in the Squim Public Library. A fraudulent protection order. Yes. Happens to have forgeries on it. Yes. And that has been used to arrest me multiple times. As I really have learned over the last 3 years about the judicial process in the United States of America, we are having a protracted conflict in the judicial process of the United States. And as the body of evidence does show, is causing great harm to my five sons. Now, you wouldn't think for every video that I made, yes, every email that I've sent since November 15th of 2015, yes, every time that you've involved me in this protracted judicial process,